Abaragani and Hotep. I'm Dr. Clyde Robertson, the Director for the Center for African and African American Studies at Southern University at New Orleans, and I'd like to welcome you to the 5th Annual Charles FRYE Memorial Lecture. In 1993, Charles FRYE arrived at Southern University at New Orleans as the Center for African and African American Studies' first full-time director. Dr. FRYE, prior to arriving here, had already secured a stellar reputation as a vibrant and widely published scholar. He continued to achieve mightily during his brief and impactful tenure at Southern University at New Orleans. In the 3 years at SUNO, wrote the late administrator Dr. Melinda Bartley, Dr. FRYE's contributions to the center, the university, the greater New Orleans community, and the state of Louisiana solidified his stature as a national and international scholar and teacher. During his 25-year career, he published 3 nonfiction books, 1 novel, and numerous articles examining the richness and depth of Black studies. He also impacted the lives of countless students, colleagues, family, and friends. On October 8, 1994, Dr. FRYE transitioned into the ancestral realm, leaving a lasting legacy of community-based commitment, camaraderie, and consciousness. Charles FRYE Memorial Lecturers are change agents who personify the values and accomplishments of Dr. Charles FRYE. Past Charles FRYE Memorial Lecturers are Dr. Eddie Glau Jr., the James S. McDonald Distinguished University Professor of African American Studies at Princeton University. Mr. Mark Morial, former mayor, City of New Orleans, and current president and CEO of the National Urban League. Ms. Donna Brazil, political activist, consultant, advisor, and pundit. And attorney Angela Bell, associate professor and B.K. Agnahatri, endowed professor at Southern University's Law Center and renowned civil rights attorney. Today's Charles FRYE Memorial Lecturer is State Representative from the 29th District, the Honorable Edmond Dwayne Jordan. Born and educated in Bruley, Louisiana, he earned an undergraduate and law degree from Southern University in Baton Rouge. In addition to being an elected official and practicing attorney, State Representative Jordan also co-owns the Cypress Insurance Company in Baton Rouge. However, as an attorney and state representative, Jordan has stood against police abuse and irregularities perpetrated against Louisiana's African American citizens. His House 51 bill sought to roll back the legal protections shielding officers from lawsuits alleging abuse. In June 2020, the Louisiana House of Representatives rejected his bill. Undeterred by the setback, this lightning rod continues to advocate for every citizen, especially those who have historically been objects of police scorn and abuse, as he elaborates in his presentation, Revisiting House Bill 51, Holding Police Accountable for Their Actions Against Louisiana's Black Citizens. And now, State Representative Edmond Jordan.
Clarence Jamison wasn't jaywalking. That was Michael Brown. He wasn't outside playing with a toy gun. That was 12-year-old Tamir Rice. He didn't look like a suspicious person. That was Elijah McClain. He wasn't suspected of selling loose, untaxed cigarettes. That was Eric Garner. He wasn't suspected of passing a counterfeit $20 bill. You all know who that was. That was George Floyd. He didn't look like anyone suspected of a crime. That was Philando Castile and Tony McDade. He wasn't mentally ill and in need of help. Unfortunately, that was Jason Harrison. He wasn't assisting an autistic patient who had just wandered away from a group home. That was Charles Kinsey. He wasn't walking home from an after-school job. That was 17-year-old James Earl Green. He wasn't walking back from a restaurant. That was Ben Brown. He wasn't hanging out on a college campus. That was Philip Gibbs. He wasn't standing outside of his apartment. Again, years ago, you probably heard of this guy. That was Amadou Diallo. He wasn't inside his apartment eating ice cream. That was Botham Jones. He wasn't sleeping in his bed. Let's say our name together. That was Breonna Taylor. He wasn't sleeping in his car. That was Rayshard Brooks. He didn't make an improper lane change. That was Sandra Bland. He didn't have a broken tail light. Again, in South Carolina, you know it, that was Walter Scott. He wasn't driving over the speed limit. That was Hannah Pfizer. He wasn't driving under the speed limit. That was Ace Perry. Clarence Jamison was a black man driving a Mercedes convertible. And as he made his way home to South Carolina from a vacation in Arizona, Jamison was pulled over and subjected to 110 minutes of an armed police officer badgering him, pressuring him, lying to him, and then searching his car from top to bottom for drugs. Nothing was found. Jamison isn't a drug courier. He's a welder. Still unsatisfied, the officer then brought out a canine to sniff the car. The dog found nothing. So nearly 2 hours after it started, the officer left Jamison by the side of the road to put his car back together. Thankfully, Jamison left the stop with his life. Unfortunately, too many others have not. The Constitution says that everyone is entitled to equal protection under the law, even at the hands of law enforcement. But over the decades, however, judges have invented a legal doctrine to protect law enforcement officers from having to face any consequences for their wrongdoing. This doctrine is called qualified immunity. And in real life, it acts more like absolute immunity. Those words that I just spoke, paraphrased them from Judge Colton Reeves, who's a judge in the Southern District of Mississippi. And I want to take a brief moment to thank Dr. Clyde Robinson and the Center for African and African American Studies here at SUNO for inviting me to serve as the Charles FRYE Memorial Lecturer for this year. It's certainly an honor and a privilege for me to speak to all of you. Fortunately, due to COVID, we can't all be together, but that does give us certainly an opportunity to do something different in forms of us presenting our topic of House Bill 51 Revisited, holding police accountable for the actions perpetrated against black citizens. My goal is certainly, by the end of this presentation, for you to have some understanding of what qualified immunity is and why getting rid of it is something that's very important to us. We're going to go through lots of different sources, and I'll try to reference them and get them up on the screen for you so that you can have a deeper understanding of what we're talking about, and also give you a reference point if you want to go back and look at this. What was HB 51? Now, I'm going to have you look at the screen right now. We're going to put that on the screen. HB 51 in part said, no element of qualified immunity or any other kind of immunity are available to law enforcement officers as a defense to liability for claims for wrongful death or physical injury by law enforcement officers. All right, so that gives you what HB 51 said. And you're hearing this term qualified immunity, and you're saying to yourself, well, Edmond, what exactly is that? You're using these words, but what are we actually talking about? Well, let's back up just for a second. So, and get back to the real topic. How are we holding police officers accountable when they violate your rights? Under normal circumstances, we use a statute, 42 USC 1983. But prior to 42 USC 1983, there was another law that was enacted by Congress. And I'm going to put that up on the screen for you to see it, because I think when you see the original basis of it, some of this is going to come to light for you. So if you'd put on the screen the Civil Rights Act of 1871, was also known as the Ku Klux Klan Act. Right there, Congress gave Americans the right to sue public officials who violate their legal rights. Again, like I said, today that act is now 42 USC 1983. Congress basically says that if a public official violates your rights, whether by police brutality, an illegal search, or an unlawful arrest, you can file a lawsuit that would hold that public official financially accountable for his conduct. So it seems like it's pretty simple, right? You had the Ku Klux Klan Act, which later became 42 USC 1983, which says, in effect, if a police officer violates your civil rights, whether it's brutality, illegal search, again, any of those type things, that you can sue them and hold them and that municipality financially accountable. Simple enough. However, there's a catch, and that catch is qualified immunity. So, what does qualified immunity say? All right, back to the screen. Qualified immunity is a special protection for government officials. Those officials can be immune from liability even if they violate your rights. In underqualified immunity, government officials can only be held accountable for violating someone's rights if a court has previously ruled that the law was clearly established. So here we go. What does that mean, right? I can hear you saying now, what does that really mean? What it means is this. Not only does a police officer have to violate your constitutional rights, they had to know prior to violating your rights that that's what they were actually doing, that there was some case. They needed some prior notice in the form of some case in their district. Some judge had ruled previously that the specific action that they were violating was already in effect. So again, here we go. It's two parts. A violation of your constitutional rights, and that violation was clearly established law. That clearly established law, in effect, means that there was a case ruled on by a court that said the officer's specific conduct was an actual violation of your constitutional rights. Now, I'm going to go through a few cases for you. We're going to go through the case of Malika Brooks. We're going to go through the case of Wayne Jones. You'll see that was a case that I presented back in June when we were talking about HB 51. And you'll hear some of the facts of those cases. Malika Brooks, I'm going to kind of recite those to you in a minute here. Wayne Jones, because of the intense nature of it, I think it's better presented the way I presented it in the hearing back in June here at the Capitol. So a question that often comes up is, well, why are we suing them civilly? If the officers are truly in the wrong and you want to hold them accountable, why don't they have criminal charges pressed against them, for instance? I would tell you to go look at a Washington Post article. The title of it, Thousands Dead, Few Prosecuted. It's a pretty good story. I want to say it's from 2015, but they talk about out of the thousands of people who were shot at the hands of law enforcement, only 54 of the people had been prosecuted. Most of them still acquitted, and never served jail time. So, look, and we have some very good prosecutors, and we have some very good people in law enforcement. So let me be clear. We're talking about people who are violating your rights. We're not talking about good cops that are out there doing their jobs every day, which a majority of them are. So I do want to make that statement clear. But what we are talking about are the ones who are violating your rights and why they aren't being held accountable. Part of it is qualified immunity. But again, let's just talk for a second. There is a relationship between prosecutors and law enforcement. Most people that are arrested for criminal conduct, who serves as witnesses? Obviously, law enforcement. So there is a relationship there. Does it make the prosecutor biased? We'd have to go and look at most cases for that. But I can tell you, very few prosecutors certainly want to bring charges against police officers. Now, I'm sure they'll say if it was egregious conduct, then they will, or criminal conduct, they're going to prosecute all criminal conduct. I can just tell you, and you look at the statistics on this, it doesn't necessarily bear itself out on it. That aside, that's a side note. We're talking about qualified immunity here today. I'm going to take you through, again, we're talking about the case of Malika Brooks. So let's start with that. Malika Brooks was a young mother driving her 11-year-old son to school. She's going through a school zone where she's clocked and the officer says she's speeding. He pulls her over, and during the confrontation, he decides he's going to write her a ticket. He calls for a backup for another officer to come because Ms. Brooks does not want to sign a ticket. She thinks it's some admission of guilt, which a lot of people do. So they get into this back and forth. And at some point, the officers say that in order to get Ms. Brooks out of her car, because she's refusing to get out of her car according to their testimony, they're going to tase her. Well, here's the catch. Ms. Brooks is 7 or 8 months pregnant. She hears them talking about that. As she hears them talking about whether they're going to tase her or they're going to tase her, she tells them she's pregnant. So then the officers start talking and say, well, we're not going to tase her in her stomach. And they say, well, where do you want to tase her? And the officers then proceed to tase Ms. Brooks in her thigh, in her neck, in her back, drag her out of the car. A woman that's 7 or 8 months pregnant, drag her out of the car in front of her 11-year-old child, turn her on her stomach, again, a woman that's pregnant, handcuff her with her hands behind her back, and take her to jail. Seems pretty egregious. But what happens is, because remember, there's two parts to qualified immunity. Violation of a constitutional right and prior established law. You have to have that notice. The court says that while it may have risen to the level of a constitutional violation, those actions by those police officers, but because there was no case that said that it was a violation to tase a pregnant woman, the cops were exonerated because by qualified immunity. Seems egregious. The case of Wayne Jones is even worse. And so what we're going to do at this point is, again, I want you to go to the screen and listen to my recitation as I spoke about Wayne Jones back in June of 2020, and just indulge us for a few minutes. I can give you another example, one that I just read last night. This gentleman, Wayne Jones, in Virginia, was homeless, suffering from schizophrenia. Instead of walking on the sidewalk, there's an ordinance that says you need to walk on the sidewalk instead of in the street. The cop sees Mr. Jones, and he asked him, basically, what are you doing? Starting a conversation with him, asking him what's his name. Looking for ID. The guy didn't have any ID. He was homeless. He asked him if he had any weapons on him. He said, well, that depends on what you call a weapon. The officer says guns, knives, whatever. And he said, well, I might have one, because he actually had a knife. He's homeless, schizophrenic, maybe he needs to protect himself. So he says, well, put your hands on the car. The guy asks, what did I do wrong? He says, put your hands on the car. Again, he asks the officer what he did wrong. The officer tases him. He takes off running. The officer calls for backup. He hides and kind of secludes himself under a stoop where they wrestled him and they put him in a chokehold. Choked him until he almost passed out. But while the cop had him in a chokehold, he felt a prick. He didn't know what it was. Later, they determined that it was a knife, but I don't know if they knew it was a knife at the time. So he's down now because he's choked out, unconscious, not moving. They start telling him to drop his weapon. They can't see it because it's tucked under his shirt. But they ask him to drop his weapon. He doesn't drop the weapon because he can't move. They choked him out. He's unconscious. They proceed to shoot him 22 times. Killed him. The district federal court granted qualified immunity to those officers. But the Fourth Circuit ruled on this just June 9th, just last week or a week and a half ago. I'm just going to read to you what Judge Floyd, oddly enough, his name is Floyd, said. He said, Wayne Jones was killed over 1 year before Ferguson, Missouri. The shooting of Michael Brown. 7 years later, we asked to decide whether it was clearly established law that 5 officers could not shoot a man 22 times as he lay motionless on the ground. Although we recognize that our police officers are often asked to make split-second decisions, we expect them to do so with respect for the dignity and worth of Black lives. Before the ink dried on this opinion, the FBI opened an investigation into yet another death of a Black man at the hands of police, this time George Floyd in Minneapolis. And I'm going to tell you, the next statement is really what kind of got to me. The judge just clearly said, this has to stop. This has to stop. To award qualified immunity at the summary judgment stage in this case would signal absolute immunity for fear-based use of deadly force, which we cannot accept. and they reversed. This has to stop. This is something that we cannot continue to accept. So I want to thank you for listening to the facts surrounding the case of Wayne Jones. So I guess you're wondering, how do we take a special session that was supposed to be dealing with tort reform, and how do we get to hear a case dealing with qualified immunity? Well, I'm going to ask you to go back to the screen again. And we had a call for the special session that dealt with over 41 items. And item number 40 said to legislate with regard to civil liability and motor vehicle liability coverage, general prescriptive periods for delictual actions, collateral source, prescription, jury trials, jury trial thresholds, direct actions against insurers, evidence regarding seatbelts, annual rate filings by the Commissioner of Insurance, and mandatory rate reductions. Now, in fairness, I would tell you, when they wrote that call, I'm sure they never intended for it to be dealing with qualified immunity. But when I looked at the very first part of it, and again, if you look and I don't know if we can highlight it or not, but if we can, we'll show you to legislate with regard to civil liability. What is qualified immunity? What have we been talking about? We've been talking about if somebody violates your rights, you can hold them accountable under 42 USC 1983 for civil liability. Qualified immunity helps them escape civil liability. So it certainly falls within that scope. And let's put some context. This was June of last year, just months after George Floyd. You know, but whether it's George Floyd or whether it's Breonna Taylor or whether it's here in Baton Rouge, we had Alton Sterling or numerous other cases. Black and brown people are being harmed in this manner disproportionately. And so it was certainly important to me. I thought the timing could not have been better. If we wanted to have a conversation, this was the conversation to have. So we went for it. Now, I will tell you this is certainly not something that I did by myself. I am the author of HB 51, but it took the help of many others for us to get to the point of even having this matter heard. And so I will tell you there were members of the Louisiana Legislative Black Caucus, there were members of the Louisiana Democratic Caucus that worked with us, and the clerk, the Speaker of the House, and others that we dealt with to actually get this to a hearing, and the committee itself on civil law. And when you start naming people, certainly you start missing out names, but I certainly want to thank Royce Duplessis out of New Orleans, Dustin Miller out of Opelousas, as well as Patrick Jefferson and Sam Jones, Mandy Landry. Those three members actually sat on the Civil Law Committee, and everyone that sat on the committee that heard this issue of qualified immunity. It took a valiant effort for us to get to this point. I will also tell you that, if a tree falls in the middle of the woods and nobody is there, does it make a sound? It's the question we always hear. We had others that came in support that day that helped strengthen my voice and amplify what we were doing. And I know I'm going to probably miss some people, but I'm going to say it anyway. Jason Hughes, Candace Newell, Tammy Phelps, Fred Jones, Kyle Green, Ted James, Marcus Bryant, Ken Brass, Travis Johnson, Randall Gaines, and Matt Willard. All of my colleagues through the entire hearing stood with me, stood for us. I will tell you, it was a moment that I will never forget. If you're looking at the picture now, it was a powerful sight to see those folks over my shoulder as I went through that closing, and as I spoke throughout the entire hearing, not just the closing, but particularly through the closing. It meant so much. I am forever grateful. And I will leave you with the words that I said in the closing of June of 2020. I want to thank you for your time. I want to thank you for your patience. Again, I want to thank Dr. Clyde Robinson and the Center for African and African American Studies at SUNO for giving me this great honor and privilege to present to you today. And please spread the word that we need to end qualified immunity. But I do want to read a couple of things, and I'll start with my closing. I want to read the letter from Congressman Richmond, because I read this morning, and I think it's important that it be read. So I'm going to read it. It was 91 when the movie Boys in the Hood came out, and the last line in the movie said, either they don't know, they don't show, or they don't care about what happens in the hood. Well, if you didn't know, now you know. There are numerous videos showing you what's happening. So then you go through the last line, and the real question is, do you care? I care. And everyone else should too. Enough is enough. I've had some more time to think since the hearing in Congress last week on police reform, and came across a quote from the director of that movie, the late John Singleton. He said, "The freshest moments in my films have always been with unknown actors." Actors are not only in movies and plays. Each one of us is an actor in the one life God gave us. George Floyd was an unknown actor. Tamir Rice was an unknown actor. Breonna Taylor was an unknown actor. Alton Sterling was an unknown actor. It's time for us to remove the immunity that gives police the impunity to take the unknown among us from their families. The U.S. Supreme Court created qualified immunity in 1967 in its ruling of Pearson v. Ray. No one disagrees that police officers have difficult jobs requiring split-second decisions based upon limited information. However, qualified immunity came into being prior to the militarization of the police. No-knock search warrants, stop and frisk, and the war on drugs. It did, however, come into being during a time when the U.S. Supreme Court was focused on protecting the constitutional rights of individuals. In the beginning, qualified immunity could have had its place. The court never would have dreamed what this well-intentioned policy choice would become. In 1982, the U.S. Supreme Court expanded qualified immunity beyond all recognition in Harlow v. Fitzgerald. Essentially, the court said that as long as no police officer in your area of the country has violated the constitutional rights of a person in exactly the precise way you just did, then it's open season on the citizenry of the United States. Since 1982, it has been practically impossible to sue a police officer, even when the court admits they violated the Constitution. And the congressman adds emphasis there. Every year, new outrages are perpetrated, and every year police are shielded by immunity the way police are supposed to shield children like 12-year-old Tamir Rice. Eventually, after every possible constitutional violation has been committed by police in every region of the country, I suppose this problem will resolve itself. But I, for one, am not willing to wait for that or tolerate the untold resulting carnage and pain. The late Justice Antonin Scalia and I have very different judicial philosophies. Justice Clarence Thomas and I have very different judicial philosophies. However, the three of us agree on the fact that qualified immunity has expanded so far that it gives the American citizens practically no redress when the police violate their constitutional rights. Not only is this something that can be fixed, it can be fixed now. Change at the federal level is slow, but here I know it's not. I sit where you sit now. We work together to quickly right the wrongs that we saw in the world because while we were from different regions of the state and different political viewpoints, we were all from Louisiana and instinctively knowing something is just flat out wrong for our great state. Here, we do not have filibusters and grand national campaigns. Here we have each other, and we all know right from wrong. The next victims of police violence will almost certainly be unknown actors. It is up to the rest of us to act on their behalf and take whatever steps we can to end police violence. This is one small step, but it is the step that is before us today. Many of you here have been upset that contact tracing or wearing a mask could violate your constitutional rights. Without getting into the merits of that argument, you would have redress in the courts, and likely the court would get to the merits of the case. Isn't the taking of a life a much more egregious violation? I'm not attempting to say that it can only happen to African Americans. It can happen to anyone, but it is much more likely to happen to African Americans. The harsh reality is that many of you would not tolerate for 5 minutes your child being policed the way I fear my son will be policed. I fear it because even today, sitting as a U.S. congressman, it still happens to me. The least that can be done is to give him an opportunity to protect his constitutional rights. Is what you would want for your child. Ladies and gentlemen, that's from a U.S. congressman. It's not a former U.S. congressman. That's not somebody that's 80 years old. That's somebody that has served in this very house and that is younger than some of us here. And that's the fear that he has for his son. That's the fear that I have for his son. That's the fear I have for Ted's daughter. That's the same fear I have for Dustin's son. You know, I had some of you have talked to me and you said the timing was not right. You know, that gets me to something that, because we all like to quote Dr. King, so I'm going to give y'all a little bit of King because I know that's what folks like. He says, we are now faced with the fact that tomorrow is today. Tomorrow is today. We are confronted with the fierce urgency of now. In this unfolding conundrum of life and history, there's such a thing as being too late. This is no time for apathy or complacency. This is a time for vigorous and positive action. He went on later in that speech to say, we refuse to believe the Bank of Justice is bankrupt. I think if I were talking to Dr. King today, he might have a different opinion. I really do. Because that was in 1963 and this is 2020 and we're still fighting the same issues. Have we made some progress? We've made some. People always like to point to that we've elected an African-American president as if that's the end-all, be-all of all of this. That we're post-racial. We're not. And I'm not trying to make this a race matter because I, like Ron Haley, I've represented people in this. I've represented African-Americans. I've had white clients as well that have suffered at the hands of police brutality. But again, just like the congressman said, it's much more likely to happen to us. Now, I know you all have your reasons for whatever you may do, and you've earned the right to do that because people have sent you here. But people have also sent me here. People have sent all of these folks who are standing with me. And I just want to say, I want to thank those young kids, BR for the people. Because I told them before we came in here, protest without policy is dead. And I've said that. I've said, just like I've said, faith without works is dead. We have to show them a better way. We have to be an example for them. So I will tell you, I am at peace with the example that I've set for them, regardless of the outcome of this decision. But I'm going to leave you with this. And I'm no biblical scholar, so I'm going to read this. But because he wished to justify himself, well, let me back up. That was a scholar of the law, because I want to make sure I get this all right, who said to Testament, said, "Teacher, what must I do to inherit an eternal life?" I said, "You're shaking your head, Patrick. I think you're going to like this." And Jesus said to him, "What is written in the law? How do you read it?" And he said in reply, "You shall love your God, your Lord, your God, with all your heart, with all your being, with all your strength, and with all your mind, and your neighbor as yourself." He replied to him, "You have answered correctly. Do this, and you will live." But because he wished to justify himself, he said to Jesus, "And who is my neighbor?" And Jesus replied, "A man fell victim to robbers as he went down from Jerusalem to Jericho. They stripped him and beat him and went off leaving him half dead. A priest happened to be going down that road, but when he saw him, he passed by on the opposite side. Likewise, a Levite came to the place, and when he saw him, he passed by on the opposite side. But a Samaritan traveler who came upon him was moved with compassion at the sight. He approached the victim, poured oil and wine over his wounds, and bandaged him. Then he lifted him on his own animal, took him to an inn, and cared for him. The next day he took out 2 silver coins and gave them to the innkeeper with the instruction, "Take care of him. If you spend more than what I've given you, I shall repay you on the way back." Which of these 3, in your opinion, was the neighbor to the robber's victim? He answered, "The one who treated him with mercy." And Jesus said, "Go and do likewise." You know, when I first read that, and I came in, I was thinking about what I was going to say. My question really was to you, who is it that are our neighbors? Or you are our neighbors? But you know what? I think I actually misread it. The real question is, do you see yourself as the Samaritan or the victim? The question really becomes, if you can't see yourself as the victim, you could never be the Samaritan. Until you can see yourself in that person, you will never have empathy for that person. So the real question is, until you can see yourselves in us, there's nothing that you can do for us. But I know that this body is willing to move forward. I know that this body wants to improve. I know that this body wants to make progress. So I'm going to pray. But again, I'm going to have faith. But like I said, faith without works is dead. So I'm going to hope today that we're going to all be alive. And however you vote, however we get to move forward, that we're going to move forward. And at some point, something touches your heart, that you see yourselves in us and us in you, so that I don't have to worry about what happens to my son or my daughter or Ted's daughter or Royce's daughter or Dustin's children or whomever else that there is that's here. I'm hoping we don't have to worry about one of them being the victim, because you know what's going to happen when you do that? You're going to say, man, I'm so sorry that that happened to you and to your family. The question is, when you had a chance to do something, what did you do? I'm going to ask for your favorable passage.
Thank you, State Representative Jordan, for your tireless efforts to uplift all citizens of the state of Louisiana, especially the African American citizens of this great state. Also, I'd like to thank you for your dynamic and passion-felt presentation. In addition, I'd like to recognize the following Southern University at New Orleans administrators: Chancellor Dr. James Amons, Title III Director and Vice Chancellor of Research and Strategic Initiatives, Dr. Brenda Jackson, Dean, the College of Arts and Sciences, Dr. Evelyn Harrell, and the Chair of the Arts and Humanities Department, Dr. Doug Marshall. Asante Sana to Ms. Linda Hill and Ms. Darlene Holmes of the Center for African and African American Studies. A great thank you goes out to Dr. Michael Meehan, Director, Satellite and Telecommunications, and Mr. Chauncey Kamen, Webmaster. And I'd also like to thank all of you for participating in the 5th annual Charles FRYE Memorial Lecture, brought to you by the Center for African and African American Studies at Southern University at New Orleans.